Hello and welcome to this lecture about company law. Now this is the first of 3 chapters dealing with company law, 5, 6 and 7. I'm afraid company law is quite hard to learn. There's a lot of dates, a lot of deadlines and a lot of rules that you've got to learn. I've tried to keep the lectures quite short so that you can sort of concentrate quite hard for a short period of time and then go away and try and learn the material. A good way to learn this stuff is to make yourself little crib sheets and to get people to test you, because it's stuff that doesn't require masses of understanding. It really is a lot of rote learning. Now, in terms of how many questions you can get on company law, you can expect round about 20 questions on the next 3 chapters, of which maybe 10 to 12 could come from this chapter. So it is a very important chapter, well worth taking your time with. Now, first thing, what is a company? Well, a company is something which is set up under the Companies Act 2006. The 2006 Act is the latest Companies Act. The last one was 1985. From time to time, they'll revamp the Companies Act, modernise the law, change things slightly. And for your studies, you only need to worry about the 2006 Act. In real life, back in the office, you will see companies that have been incorporated under the 85 Act or even an earlier Act. But for us, we'll just focus on this one. You will see a lot of section numbers in here because company law is mainly statute based. You don't need to know these section numbers. They're there really sort of for reference if you ever wanted to check a point out. Okay, so the first point to note then, what is important about a company? Well, a key point about a company is that it has a separate legal personality, a separate legal identity to its shareholders, those are the company's owners, and also to its directors, the people who manage it, its managers. Now, that means several things, and we've just summarised those points here. First of all, a company is an artificial person. That means that a company has the power to enter into contracts, it has the power to sue and be sued, has the power to hold property, which is mentioned here. It also means that for the purposes of legislation, anywhere in the legislation where it talks about person, that will include a company, an artificial legal person. Now, another key point in company law is that the shareholders of a company have limited liability. Now, be really careful here. You'll notice I didn't say that a company has limited liability. That is wrong. It's the shareholders, as we'll see in a moment, who have the benefit of limited liability. Also, another point about a company is that it has continual succession, or sometimes called perpetual succession. And what that means is a company will go on in perpetuity, it will go on forever, unless it's formally wound up. It doesn't matter if a director dies or a shareholder dies, that company will continue to exist. Now, as a company, as a legal entity, it can be sued in tort, and we saw that in some of the previous examples in negligence. Also, a company can be guilty of a crime. Now, it's pretty difficult to prosecute a company for a crime. And there have been a very small number of successful prosecutions. Probably the lead one was over the Lyme Bay canoeing tragedy, where a company was employed to take school children on canoeing trips in Lyme Bay. The instructors weren't trained and they made mistakes which led to the deaths of the children. In that case, the managing director of the company went to prison for 3 years. In general, it's pretty difficult to identify who should go to prison in a company, because you have to identify, sort of ultimately, even if you prosecute the company, ultimately there has to be an individual who takes responsibility. And it has been said that the bigger the company, the more difficult it is to pin that on any one person. And therefore, in very big companies, it's possibly that it's less likely that a claim will succeed. Now, the lead case in demonstrating separate legal personality of a company is this case Salomon v Salomon. And if you're going to know a case name, this is probably one of the ones that is worth you learning. And this case established the principle that a company has a separate legal personality to its shareholders and also to its directors. Now, in this case, Mr. Salomon ran a company. What's the best place to draw a picture here? squeeze it in down here. No. In this case, Mr. Salomon ran a company. So Salomon owned a business, and it was decided that he would transfer his business to a company. So he sold his business to a company. The company was already set up, and Mr. Salomon had 1 share, and some members of his family owned the other 6 shares. But in return for transferring his business to the company, Mr. Salomon received some cash. He received an IOU from the company, which was secured on the company's assets, and he received some more shares. Okay, that was his consideration. So to all intents and purposes, Mr. Salomon owned this company. His family had a very small number of shares, but weren't involved in the running of the company either. Now, through no fault of Mr. Salomon's, the company didn't prosper. And within about a year of being incorporated, the business failed, leaving a lot of debts. Mr. Salomon, to add insult to injury, exercised his security for this IOU and actually took one of the last slices of profits that were left in the company to pay his own debt. Now, as you can imagine, the creditors weren't very happy about this, and the liquidators who were brought in to wind up the company tried to take the case to court. And even at the Court of Appeal, which is a very senior, eminent court, the court felt that as Mr. Salomon actually owned all the shares in this company bar 6 and ran the company, then it was effectively still his company. And therefore, even the Court of Appeal felt that Mr. Salomon should be liable to indemnify the creditors of the company against that company's liabilities. However, the House of Lords looked at this situation and they said that it doesn't matter who owns the business, the debts are the liabilities of the company and the company only, because the company is a separate legal personality. Therefore, the debts stayed with the company. It wasn't possible to make Mr. Salomon liable for those debts of the company, even though he was the director and pretty much the sole shareholder. They also said that the fact that Mr. Salomon had exercised security to get himself repaid for those debts for the IOU, that didn't matter because he was following proper legal procedures and he was enforcing his security in just the same way as any other secured creditor would have done. So the claim by the creditors failed. Mr. Salomon was protected by limited liability. And that's a point that we're going to explore in a little bit more detail in this section here. So the fact that a company is distinct from its members means that the members may enjoy limited liability. And remember, that means the company must pay its debts in full. That's very important, right up until it's run out of money. And once the company has run out of money, the shareholders are not liable to contribute any further. Now, when we say the shareholders have limited liability, what do we actually mean there? Well, that depends on the sort of company that we're looking at. Most companies are limited by shares. That means that the company has issued shares to its shareholders. They've agreed to pay a sum up to the nominal value of those shares. The nominal value. By nominal value, I mean almost the face value of the share. So if it's a £1 share, the nominal value is £1, even if the market value of that share, the price you could sell it at, is much higher or even much lower. So the shareholder's liability is limited to the nominal value of the shares. That's the amount he's agreed to pay to the company. Now, in many cases, that money will be paid up front, and the shares will be what we call fully paid. So if you own a £1 share, you've paid £1 to the company. Therefore, if that company is wound up, you don't owe anything extra. You've paid it already. If your share's only partly paid up, then that means that you'll have to pay over the balance up to the level of your nominal value. So if you've bought a £1 share, but so far you've only paid 70p on that share, you'll have to pay the other 30p when the company is wound up. Finally, we might have shares that are issued at what we call a share premium. So this is where we might have, for example, a £1 share which is issued at £10. Okay. Now, if you buy a share at a share premium, then the initial purchaser of that share, the subscriber for that share, owes the full £10. So if the company is wound up and that £10 hasn't been paid over, you must pay it over. However, if you have sold those shares on to someone else, so you as a partly paid share, that subsequent shareholder is not liable to pay the premium over to the company. So the premium kind of drops out, if you like. It's only a debt that attaches to the initial shareholder, the subscriber for the share. Now, there is one other sort of company which you may not have heard of, and that is a company which is limited by guarantee. Now, in this case, the company has no shares, doesn't issue shares at all. Instead, the guarantors sign a piece of paper that says that they are prepared to contribute a certain amount of money to the company on a winding up. So the guarantors agree to pay a sum on a winding up. So they don't pay it over up front, only when the company's wound up, and only then if the company can't actually pay its own debts. So if you have a company that's limited by guarantee, the liability of the guarantor is the amount that they agreed to pay. Okay, so that's very important information in that table. Make sure you're comfortable with it. So you're only liable up to the amount of the nominal value of your shares. If the shares issued at a share premium, you are liable up to the amount of the share premium, but only the initial shareholder. Subsequent shareholders are only liable up to the nominal value. Company is limited by guarantee. It's the amount you've agreed to guarantee. Now, following on from the Solomon case then, we've got to a position where we have the shareholder here owning the company. We'll call it Company Limited. And therefore we have something which is called the veil of incorporation, like a shield, if you like, between the company and the shareholders. And most people who do business with this company won't mind. They won't know who the shareholders are. For instance, you go into Boots and buy your lunch one day. You don't care who owns shares in Boots PLC that day. You are doing business with the company. Okay, and for most cases, this veil of incorporation will stay in place. It's the company that's important, not the people that own it, and not the people who are managing it. But in some circumstances, this can give a really unfair result, and sometimes this veil will need to be lifted. And in this case, we lift the veil and we look behind the company in order to see what's really going on. And in those circumstances, this limited liability of the shareholders, the fact that the shareholders and the directors are not personally liable for the acts of the company, may change. So we need to have a look at when that might happen. And there's been a lot of cases to test this. This is also something that the examiner quite likes as well. So the first block of cases we're going to look at concern groups of companies. So we might have Company A, which also owns Company B, and maybe Company C, and possibly even Company D Limited. Now, you might like to think that the actions of any one of those companies affect all of them. However, as a strict legal principle, each one of these companies is a separate legal entity. And therefore, if Company D Limited can't pay its debts, we wouldn't normally look to its owner, Company B Limited, to pay the debts for it. However, in some circumstances, the courts will look behind the veil and may treat a group of companies as if they were a single entity. Now, the first thing the courts have said is that they would need to regard one company as acting as an agent of the other company. And they need a reason, they need an excuse. So we've got some excuses here. First of all, to produce a tax liability. And this is a case where an English subsidiary, so the subsidiary would be, in this case, D Limited is a subsidiary of B Limited. B Limited is a subsidiary of A Limited. A Limited is the top company there. It's the holding company or the parent company. So in the Firestone case, the American company was actually operating in the UK through a subsidiary, and the subsidiary was acting as an agent in entering into contracts and so on for the US company. But due to a bit of clever tax planning, there was no established tax liability in the UK. And the courts looked at this structure and said, well, actually, the subsidiary is acting as an agent for Company A. We will create a tax liability in this scenario. And that meant shifting some of the profits sort of artificially back from the American company into the subsidiary. Similarly, the courts are happy to use this power to prevent tax evasion. And this was a case where the top company, the holding company, was actually, we had a top company and a subsidiary, and they were actually moving assets around between them as if they were the same entity. And the court said, well, that's fine, if you can do that, so can we. And they treated the companies as if they were the same company. Another one, which was actually in the company's favour, was to give entitlement to compensation. In this one, we had holding company, which owned a property, and subsidiary, which occupied the property. Now, these companies, this was 100% owned. Then we had company directors who were also shareholders who owned H Limited. And in this case, compensation was going to be paid to the owner-occupiers of certain properties. Now, that meant that because this particular property was owned by a holding company, but then occupied by the subsidiary, then the directors and shareholders of this company wouldn't get any compensation. And in this case, the court looked at that and said, no, in this case, we'll treat H&S as if they are the same entity. So effectively lifting the veil, treating them as one entity. So the company could claim compensation. However, the courts have not been prepared to lift the veil just because an insolvent company, subsidiary, couldn't pay its debts, even though its parent could. Or where a claimant thought, well, actually, I'll sue the parent because it's more wealthy. So if you have a wealthy parent and a very poor, relatively poor subsidiary, you're still going to have to sue the subsidiary if that's where your claim lies. You can't just try and follow the money. Now, there are some situations where the court has lifted the veil. Moving away from groups now, we're just looking at general situations. And the first one, very famous case, to expose the true identity of a company. Now, in this case, Daimler Company owed money to CTR. And this was during the war years, if you look at the date there. And during that time, it was a criminal offence to trade with the enemy. And Daimler were very worried that if they paid CTR what they owed them, they would be seen to be trading with the enemy. Because CTR at that point had an English secretary, it had one English shareholder, but all the rest were German. So the case went to court, and the company said, but we're an English company, we're registered under UK law. But the courts lifted the veil and said, well, actually your shareholders are German. Therefore, you are a German company, and Daimler didn't have to pay what they owed to CTR until after the war. Another example, which I always think is quite sad, is the Ebrahimi case. Now, I'll tell you about Ebrahimi because he comes up again later in the notes. In this case, Mr. Ebrahimi and his friend, who was called Nazir, operated the Westbourne Galleries, and they ran the business together. It was a company, but they owned 50% each, and they made all the decisions jointly. Now, one day, Mr. Nazir came to Ebrahimi and he said, my son wants to join the business. So it was agreed that both Mr. Ebrahimi and Mr. Nazir would give the son 10% of their shares. So we then had a position where it was owned 40% by Ebrahimi, 40% by Nazir, and 20% by the son. So they each had their shares in the company. The first thing Mr. Nazir and his son did on getting this shareholding sorted out was to band together, which gave them a 60% stake in the company, to remove Mr. Ebrahimi from the board of directors. Now, that is perfectly legal. However, not exactly fair or moral. So Mr. Ebrahimi went to the court and he asked for the partnership to be wound up and for his investment in the partnership to be paid out to him on the grounds that it's just and equitable. We'll see that later on. And the court said, well, actually, as a matter of strict law, what they did is actually fine. It's allowed. However, they will lift the veil and look at how this company is being run. And this company is in effect what we call a quasi-partnership. Although it is in a company corporate format, it's really a partnership. It's a business between two traders, and therefore it was justified in winding the company up. Another case, a couple of cases actually, is where the courts have felt that the company was actually a sham. It was set up but didn't really have any real purpose. In the Guildford Motor Company case, Mr. Horn was using the company to hide from his legal obligations. And in this case, Mr. Horn had a contract of employment with his old employer, which had a restrictive trade covenant in there. And this provision said that once Mr. Horn had left his previous employment, he couldn't work for a competitor within a set period within that locality. So pretty common clause to have there. But Mr. Horn wanted to compete. So what he did, he set up a new company and he started to operate his own business, competing with his previous employer through that company. Now, when his previous employer complained and said, "You're breaking your restraint of trade clause," Mr. Horn said, quite cleverly, "It's not me. I'm not doing that. It's my company, which is a separate legal entity." Now, in this situation, the court said, you couldn't do that. The company is just something he's hiding behind to try and shelter from his injunction, his existing legal obligations, and therefore Mr. Horn had to stop competing and pay his previous employer damages. Another example I quite like is the FG Films case. In this case, there were tax benefits available to companies who made a film, an English film, and that was defined in the legislation. So a particular company was set up, FG Films Limited, to make an English film, take advantage of the tax breaks. However, it was found that this particular film company, although it was formed under English law, was therefore technically an English company, was financed by the Americans. The staff were all American. The film was made in India. In fact, when they looked into it, nothing at all actually happened in the UK, except that this company was registered in the UK. And for that reason, the courts lifted the veil and said the tax breaks weren't available. This was not an English film. Now, that was all case law we've looked at so far. There are also some provisions in the legislation which provide for the veil to be lifted. And it's worth knowing these. So, first of all, where a director is disqualified. Now, there is provision, which we'll see later, for company directors who've misbehaved to be disqualified from acting as directors. And if they try and act as a director or otherwise be involved in the management of a company whilst they're banned, then they can be personally liable for the company's debts. So that can give the directors a personal liability. So again, we're lifting the veil. We're saying, well, okay, strictly speaking, the directors run the company, but they do not have personal liability. In this situation, they do. Similarly, where a company is being wound up, we have two provisions, which I'm not going to talk about now because we come back to them later, but fraudulent and wrongful trading. And this is about the conduct of the directors. Now, directors are guilty of fraudulent and wrongful trading, again, can be asked to make a personal contribution to the company's assets. So if the company can't pay its debts, the courts might look to the directors and take their assets and use them to pay the company's debts. The third one is trading without a trading certificate. Now, a public company, and only a public company, which we'll see later, has to get a special certificate from the company registrar before it starts to trade, saying that it's met certain requirements. If it doesn't do so, the directors may be personally liable for any debts of the company, in respect of any contracts that have been entered into before that trading certificate was obtained. Okay, that takes us to the end of this first chapter about sort of the types of company and company liability. What we will do in the next chapter is we're going to look at some more detail at the different types of company, and after that we'll look at the formation of companies.